providing access to sexual and reproductive health and rights, information and services. Reclaiming sovereignty and decoloniality means critical interrogation of the process through which research is produced, validated, and disseminated. It also entails participatory action research with African values. We need to define and control the narrative and also affirm the positive African context in the research that then feeds into laws, policies, programmatic interventions, and institutions that respond to the problems around access to sexual and reproductive health and rights. So the rights of marginalized communities should not only be spoken about, their voices should be heard, and they should be regarded as knowers of knowledge across the life cycle. So we need to move from just authorship of theory, but also to build African theory, for example, philosophical underpinnings such as radical African feminism, etc. And we also need to affirm dignity, which is rooted in Ubuntu. Then the Maputo Protocol, the Banjul chapters, they affirm the age of consent through various provisions. I will not really delve much into that, but there is Article 5 on elimination of harmful practices, Article 11, Article 6, which clarifies that the age of consent and free marriage rights should be read together with the African Charter. Then in Banjul, Articles 5, 17, 18.3. And we also see across these instruments targeted protection of women and girls. For example, special protection accorded to older women, special protection accorded to women with disabilities, and protection for women in distress. That's protection of women who are involved maybe in conflict situations and other humanitarian contexts. Then to bring you back home in terms of the jurisprudence that we have experienced in Zimbabwe around age of consent, you have heard about the Kawinda case, the landmark judgment which changed the age of consent to 18. And I will infuse this jurisprudence with issues around the reality of teenage sexual activity. And in that judgment, the judge ruled and affirmed and confirmed that healthcare providers must be empowered by the law to provide sexual and reproductive health services to children in need of such services without regarding the children as too young to need them. Whilst it is highly desirable for children to stay away from sex until they're adults, in practice they often don't do so, and children who have sexual relations have a right to healthcare services despite their youthfulness. In the Mzulu case, I think, which has also been spoken about in this meeting, the court ruled that the relevant provision of the Marriages Act, Chapter 5.11, that permitted and facilitated child marriages was unconstitutional. We also have the Women and Law in Southern Africa Talent for Gate case, which sought expansion of grounds for termination of pregnancy to accord termination of pregnancy to children who will have been sexually violated, and an expansion of grounds to women who will have been violated through marital rape. We also have the case of State versus Brian Masuku. This is a High Court 2015 judgment. The accused was convicted of contravening Section 70 of the Criminal Law Code, which dealt with having sexual intercourse with a young person. And in that case, the judge alluded to the prevalence of teenage sexual activity through making reference to statistics, which reflected that at that at that time, 66% of teenagers between 15 and 19 indulged in unprotected sex. And the judge said, ignoring the reality of consensual sex among teenagers and adopting an formalist approach to the crime can result not only in an unnecessarily punitive sentence, but also a criminal record and stigmatization of the sex offender. Then we have the case of Legal Resources Foundation versus Minister of Health and Child Care. This case argued that provisions of the Public Health Act unfairly and dangerously obstruct young people's access to sexual and reproductive health and rights. The case involved a challenge around informed consent for access to sexual and reproductive health and rights. The reasoning in this case leaned heavily on characterization of children as vulnerable, inherently vulnerable persons who need protection when consenting. So I would say we have two main challenges, two practical barriers to effective implementation of the law in Zimbabwe. Firstly, the triangulation of laws. We all know that when a piece of legislation is reformed or introduced, it has to also be triangulated with other existing laws. And this takes quite some time. I will just give an example as I take you through the journey that the age of consent reforms have traveled through various related statutes. In 2007, our Domestic Violence Act defined child marriages, forced marriages as harmful cultural practice. In 2013, our Constitution set out rights of the children. In 2016, the Muzuru case outlawed child marriages. In 2016, the General Laws Amendment Act removed criminal penalty for children having sex with each other. In 2021, 2021 to 2022, the Kawenda judgment instigated the law reform process for a new law protecting children from sexual exploitation. And then in 2022, we then arrived to our New Marriages Act, Chapter 5.17. So you can see the journey that we have traveled since 2007 up to 2022, trying to put all these pieces of legislation together so that they speak to each other. Then the other challenge, which is key, relates to the practicalities of law reform in Zimbabwe. First of all, we have courts that have interpreted judgments that have been celebrated, but we all know that it doesn't stop there. The law has to be reformed and take effect, and it has to be implemented for us to then realize access to justice, access to reproductive justice. So I'll take you through again a journey of law reform around the age of consent. I've spoken about the 2023 Constitutional Court judgment, which declared Section 70 of the Code unconstitutional. We then got the Constitutional Court giving guidance that that law should be deleted from the law books. And it gave the lawmakers 12 months. That is, they should have, by May 2023, created a new law that protects children from sexual exploitation. This was not done. 24 May 2023, no law had been created, so no crime existed to protect children from sexual exploitation. It's provided by the 2022 judgment. As of 12 January 2024, the President used his presidential powers through the Presidential Powers Act to put regulations through a statutory instrument for the protection of minors. That was a temporary measure that took effect for 6 months. As of 7 March 2024, parliamentary processes started for the creation of the new law, debating the draft law which was then passed by Parliament on 9 July 2024. So there was that lacuna until 18 September 2024. the new law was then created in the manner of the Criminal Law Protection of Children and Young Persons Act. So what does this mean? During the time that there was that lacuna, there was no law. The police could not arrest perpetrators of sex with minor girls. Sentences were reviewed on the basis that there was non-existent law. Those who had been arrested on charges of sex with minors could not be tried in the absence of a statutory instrument. It also meant that women and girls were still being abused and there was no law to protect them. The prosecution could not prosecute in the absence of a law, and child marriages, although they were outlawed, there was no single prosecution. And we refer you to the case of the famous Madzibaba Ishmael, who has not been charged with child marriage up to date. So yeah, in ending, my reflections are that the law can only do so much to protect, especially adolescents, by discouraging sex and access to sexual and reproductive health and rights. Increasing the age of consent helps protect adolescents from adult perpetrators, but should not be a barrier to access to sexual and reproductive health and rights. Policymakers and society, in accepting the prevalence of youth sex, should fashion appropriate interventions, and states should re-evaluate laws that are designed to protect girls so that they do not infringe on other rights, and also direct confrontation of their dignity and autonomy. And there's also structural problems in accessibility to African mechanisms. I think Abigail spoke about it yesterday, that because there's a dearth in jurisprudence, especially from the African Commission, it also signifies that it is difficult for the ordinary girl from Marange who was speaking here, the lady, to get access to such mechanisms. So we need to utilize the low-hanging fruits, like the Committee on the Rights and Welfare of the Children, maybe on non-contentious issues that are not marred by politics, to advance sexual reproductive health and rights. I thank you.
Thank you so much, Dr. Ndlovu, for that presentation. I think to move swiftly along, as I'm quite aware of time, if I can ask Sally to come up on the screen. Sally, across your advocacy work, we do have Sally, am I correct?
Yes, I hope you can hear me.
Yes. All right, Sally, across your advocacy work in Southern Africa, how have you actually seen the cultural authenticity defense deployed against efforts to end child marriage? What does it sound like in the room when someone makes that argument?
Thank you so much. Allow me to observe the protocols that have been observed before me, and greetings from Equality Now, from us, and really appreciating this space and this opportunity to reflect, learn and unlearn, and reconnect with each other with renewed and rewiring our energies in this current context. So Equality Now is a human rights organization working worldwide to promote legal equality, address systemic change so that we achieve a just world for women and girls and a just world for us all. So as we have been engaging specifically on issues to do with ending child marriage, the defense that have emerged does not show up in rooms as we support child marriage, or we really are opposition, or we are really anti-rights. It comes in different narratives that starts with, that's our culture. That's a foreign value system you are bringing in here. It's not, we have always done these things, so children, or we have been married when we were young and we didn't come out badly. Or it has been how we do things. We cannot be prescribed by the foreign interest, by the international non-governmental organizations, and even with the treaty bodies that are in Geneva, that are in New York. That's an African. So you see the first one really painting on marriage at this age. She already looks mature enough and ready for marriage. So she's already sexually active and she's pregnant, and she's in love, however it gets framed. So it then comes in with that kind of narrative and positioning, which is very misleading and which is not appropriate, because our African culture has its own way of it being what it is, and it is not static, it has been evolving. The second move is around authority laundering. You hear that, the practice is timeless, it's unanimously a cultural issue, and, it's contested because communities have been evolving, and there are already community-based solutions that are not codified, that have already moved on from such practices. You also begin to hear some of the humoring, the language, the naming, the narrative one, oh, you can't touch our monarchy. You can put in all your laws, but this is our monarchy. They have to do what they want. They have to choose the wife that they want. So in SADC region, it becomes very disturbing in the kingdoms, because you then hear, oh, the law can apply to anyone else, but don't touch our monarchy, right? And then you then move to the third layer, which is the procedural issue, to say, no, it's a customary law matter. It cannot be considered here. Procedurally, it belongs to the traditional authorities, not the courtrooms. It has no space, in the context of constitutionalism, in the context of the national development agenda. Just let it be handled, in that space. So culture is real and ours to redefine. And honestly, when we look into the authentic position of it, it's not a practice, and it's really something that have reformed, and a betrayal of culture for those that normalize child marriage in that effect. And then what is also disturbing is you then begin to hear that it's a protection issue. We are protecting children from poverty. We are protecting them from conflict, from harmful situations. But when we look at it really, how have girls been protected by being in a marital situation? It's a lifelong sentence of multiple violations of rights for a longest of time. So generally, when we look at that, really, we then see that advocating or ending child marriage as a narrative is not anti-African, and it's not a fight against our culture. It is actually an affirmation of our culture's capacity to evolve and to protect children. Unfortunately, the African human rights system and mechanism in the African law stages have already defined that and answered that for us. We have the African Charter on the rights and welfare of the child, which have already provided.
Are you seeking advanced qualifications in sexual and reproductive health? Look no further than Ahaki Institute, a licensed higher learning institution. Our programs are designed to equip you with the essential knowledge and practical skills to tackle pressing health challenges, influence policy, and advance reproductive justice. With a flexible learning structure of 70% virtual and 30% in-person sessions, all courses are fully accredited by the National Council for Higher Education. For more information, visit www.ahakiinstitute.ac or call WhatsApp 0744 616 801 or 0773 016 853. Ahaki Institute, nurturing multidisciplinary professionals.
By the African people, in consultation with African people, with the language, the negotiations, the experiences, the research that is grounded in our African realities, and also reflecting on our constitutional values. The same with the Southern Africa Development Community as a community. There is a static model law on ending child marriage, which we celebrate in this moment because it has been a decade since it was adopted. And with it, it has named that we cannot make room for cultural difference to find space. So the good thing is that our regional mechanism, our continental mechanism have painted that picture. Now we move to the example of the courtroom. We have the Muzuru and other cases versus Minister of Justice, the Zimbabwe case. I will not belabor by continuously talking more around it. But because I know that we have a round two of conversations, allow me to conclude and end to say, when we look at the African constitutionalism, the African jurisprudence, in African treaties and in African parliamentary commitments, the model laws that have been established and the lived realities of the African girls, allow me to conclude that the question before us is not whether child marriage is compatible with African identity or culture. Our own legal instruments have already answered that. Our own courts have already answered the question, and our own parliamentary processes have answered that question consistently. The real question is whether we are ready with courage to ensure enforcement, implementation, oversight, accountability, adequate resourcing to ensure that what is secured on paper is in the lived realities. And we have seen brave survivors, girls in the African continent, pushbacking and breeding this culture of actually naming that it's a rights issue. It's not a protection issue to preserve institutions and not protect rights. So when we reclaim legal identity of Africa, we are not preserving discrimination. So we need to reclaim the values that have always defined the best of our continent: human dignity, equality, and justice, unwavering but commitment to protecting every child. So I'll pause for now, and then we'll talk about the other processes in the next cycle. Thank you, and over.
Thank you so much, Sally. I'm sure you can hear the applause in the room. I think your mention of the various arguments that are mounted against amounted in cultural authenticity language are also just a reflection of what we've heard over the last few days, over how, if we are not careful, and I think my sister Swungile said this yesterday, if we're not careful, we will see a regression in what we've built as Africans in over so many years, and what the right wing will use is our own language, our own cultural ideals, our own cultural authenticity against us in order to confuse us, to say that what the gains that we've made are not actually gains, but a regression in our own cultural authenticity. So that is something that we need to be cautious of, and we need to look out for. And I think I should just move on quite quickly to our next speaker. Ms. Nare, from this spatial rapporteur, how do you read the relationship between the Maputo Protocol's own provisions and the cultural authenticity of defense now being mounted against them?
Good morning, everyone. Thank you, Madam Moderator, for giving me the floor. My name is Musupatsila Nare. Musupatsila is a Sotho name. It translates to someone who shows the way. I'm hoping that this morning I'll join this powerful panel of women here in showing the way and trying to answer the questions that are before us, before this Baraza. So as the moderator has already said, I support the mandate of the Special Rapporteur on the Rights of Women in Africa, the Honorable Commissioner Janet Salanjai, who joined us yesterday virtually. Unfortunately, she is not able to be with us on the ground. So listening to the previous speaker, Madam Sally, I can confirm that the Office of the Special Rapporteur is really in sync with what she was saying. So I almost felt like she was preempting what I'm going to say. The mandate of the Special Rapporteur on the Rights of Women in Africa, it is a mechanism of the African Commission on Human and People's Rights, which is a focal point for the protection and the promotion of the rights of women in Africa. The mandate of the Special Rapporteur, it offers guidance to member states, it offers guidance to NHRIs, CSOs and other stakeholders on what needs to be done in order for women and girls across the African continent to enjoy their rights as already contained in the various human rights instruments that have been talked about, even here, the African Charter, the Maputo Protocol, and other instruments. So the question that has been posed to me this morning is that from the Office of the Special Rapporteur, how do we read the relationship between the Maputo Protocol's own provisions and the cultural authenticity defense now being mounted against them. So I think the first point that we need to be clear about is what is meant by cultural authenticity. Genuine cultural authenticity has already been pointed out by the other speakers. It is, of course, about preserving Africa's rich and diverse identities, values, and traditions. But this cannot mean preserving practices simply because they are long-standing, like what Sally was saying, that child marriage has always been a part of us. We cannot preserve such practices because they are long-standing, because we have heard it for the longest time, irrespective of whether they violate the dignity, the equality, and the rights of women and girls. In this context, cultural authenticity defense refers to the argument that we have been hearing that certain cultural, religious, and traditional values are uniquely African and should therefore take precedence or even limit the application of particular human rights standards. It is increasingly used to suggest that women's rights, particularly on the subject matter of the Baraza relating to access to SRHR, bodily economy, bodily autonomy, equality, and reproductive rights, are somehow foreign to Africa or imposed from outside the continent. When provisions on SRHR, as set out under Article 14 of the Maputo Protocol, we have provisions relating to equality within marriage. Excuse me. We also have provisions relating to the elimination of harmful practices, which are all under the Maputo Protocol. We cannot now then say that these provisions are inconsistent with authentic African culture or African family values or African morality. Proponents, therefore, they contend that these provisions should either be narrowly interpreted or modified to align with what they characterize as traditional African norms. So from the perspectives of the Special Rapporteur on the Rights of Women in Africa, this presents a false contrast between the African culture and women's human rights. It is actually problematic for a number of reasons. Firstly, it overlooks a fundamental fact which has already been mentioned in this room, that the Maputo Protocol is itself an authentically African instrument which was negotiated and adopted by African states to actually respond to African challenges. So now to then say that these instruments which speaks about equality, human dignity of women is an African will be a misrepresentation, because this instrument actually speaks to the rights of women in Africa, responding to their daily challenges. So what we need to notice that the Maputo Protocol, it advances human dignity, solidarity, justice, mutual respect, and equality. Therefore, to actually portray it as external to African values would misunderstand both its origins and its purpose as well. Secondly, the cultural authenticity defense, Sally mentioned it, that it might actually treat culture as static rather than dynamic. African human rights law recognizes that culture evolves and that customs and traditions, like oaths, legal and social norms, must develop in ways that uphold human dignity and equality. Also, this culture on this argument on cultural authenticity, it also invokes culture selectively. It seeks to preserve practices that disadvantage women and girls, while overlooking the many African traditions that have historically affirmed women's leadership, community participation, dignity, and equal worth. If you look into Maputo Protocol, Article 2 requires states to combat all forms of discrimination against women. Article 4 obliges states to eliminate all forms of violence against women. Article 5 goes further by specifically requiring states to prohibit harmful practices. At the same time, if you read Article 17 of Maputo Protocol, it affirms women's rights to live in a positive cultural context and to participate freely in the cultural life of their communities. The significance of this particular provision is usually overlooked. It demonstrates that the protocol is not anti-culture. Rather, it seeks to ensure that culture evolves in a manner that is consistent with the human dignity, with the equality and the rights of women all over Africa. If you also look at the African Charter, it also has a similar approach. Article 17 also protects the rights of every individual to participate freely in their cultural life. Read together, these provisions, they demonstrate that the African human rights system does not present culture and human rights as competing values. Rather, it distinguishes between culture as a source of identity, belonging, and social cohesion, which deserves protection, and on the other hand, harmful cultural practices which must be transformed when they violate the rights of women and girls. This approach has also been reinforced in the Commission's jurisprudence in Senate Masupa and others versus Kingdom of Lesotho. The Commission was asked to determine whether the exclusion of firstborn daughters from succeeding to hereditary chieftainship could be justified on the basis of customary law. In that, in that case, Ms. Senate challenged Section 10 of Lesotho's Chieftainship Act, which automatically excluded firstborn daughters from inheriting chieftainship while allowing male descendants to succeed. The exclusion was defended largely on the basis that it reflected customary rules governing traditional leadership. So the Commission recognized that traditional leadership forms an important part of Africa's cultural heritage. However, it made it equally clear that customary institutions are not immune to human rights scrutiny. The customs and traditions cannot be relied upon to justify discrimination based solely on sex and must be interpreted consistently with both the African Charter as well as the Maputo Protocol. So even though this case does not maybe relate to the issue of SIHR, but its broader significance, it established an important principle. Tradition cannot be invoked as a defense for discrimination. Where a customary rule excludes women solely because they are women, states have a positive obligation under the Maputo Protocol to reform that rule. At the same time, Article 17 reminds us that women have the right not only to participate in cultural life, but also to shape the evolution of culture itself. So as I'm about to wrap up, from the perspectives of the Special Rapporteur on the Rights of Women in Africa, this is precisely how the relationship between the Maputo Protocol and claims of cultural authenticity is understood. The protocol does not reject African culture, it rejects the misuse of culture to legitimize discrimination. The challenge, therefore, is to ensure that our cultures continue to evolve in ways that preserve their richness while also affirming the equal dignity and worth of every woman and girl across Africa. The Maputo Protocol provides the normative framework for achieving precisely that balance. I'll end here for now. Thank you.
Thank you so much, Ms. Larry. I think that, that was really powerful, that we shouldn't use culture as a fence to push discrimination. I'm going to do something a little bit unorthodox. We have a second round of a bit of a presentation from our speakers, but we are running significantly over time. So what I'll do is I'll take a round of questions now, and then I'll ask my panelists that as they are coming up to present their second 5-minute presentation, that they answer the questions as well. I hope that the audience can indulge that. I'll take 3 questions. If those with the microphones, we've got microphones on the tables. All right, thank you. I see one hand, 2 hands, going once, going twice, sold. All right, thank you.
I've got a question for Mr. Patila. So thank you for affirming what we've always known about Maputo Protocol and its relationship to culture. The thing that has been very confusing, I think, for us is understanding the threats that we face right now and the African Commission's push for member states to ratify the African Union Convention on Ending Violence Against Women and Girls that has these regressive provisions that I was talking about, where family is defined as provided for under national law. And we also see how in the prevention of violence, it says family values, must be kind of used for that, and then it comes up with new concepts like positive masculinity. So these are the things that we are so afraid of, right, when we say the convention is regressive. So how does the office that you kind of represent reconcile pushing for the ratification of a convention that carries normative regression, normative incoherence, fragmentation of normative standards, and just like structural flaws? Because our concern is that a convention that is drafted in this way with this kind of level of challenges makes it hard to identify the right and the nature of the state obligation. And it actually takes us to this territory that we are scared of, where the standards are no longer known. Member states are saying, yeah, but this convention says whatever it is that I say is family, So it just makes it harder to assess what we got from CEDAW, from Maputo Protocol, and other normative standards, of the Commission. So just trying to understand how this is kind of being reconciled at this juncture.
Thank you. I had a second hand over that side of the room.
Yes, thank you. Mine is a short question directed to Audrey from Colombia. So you mentioned that Colombia has one of the most progressive constitutional frameworks in Latin America, even though awareness remains a challenge. So I'm just curious to know about how Colombia reached this point, and was this always the country's position, or did it evolve over time? And if it evolved, what role did CSOs play, and what strategies did they get right, so that we learn from you? Thank you.
Thank you. And the last question over there.
Thank you so much. So 2 questions, each go to the 2 sets of panelists from Latin America and Africa. What do you think the role of the older persons protocols in both regions is in addressing some of the challenges? And then for the panelists from Africa, any of you can take a question. Do you think, I know it's a bit difficult to do now, but do you think we need to reopen the debate about problematizing the legal fiction of who a child is? Yeah, thank you.
Thank you so much to those questions. I can see that the audience has been paying attention. All right, so going back to Brazil, Letitia, you've also gone up against a coordinated strategy replicating near identical anti-rights bills across your country. When you hear this room describe the draft African Charter on Family Sovereignty and Values, does that pattern feel familiar to you? Thank you.
So thank you for the question. I think this question is a little bit easier to answer, so I will try to make my contribution shorter. and also because I also talked too much at the first time and I want to listen to the other colleagues. But as I told you before, we are facing the growth of the anti-rights movement in Brazil, including in our legislative, and we are having elections this year, and I think, unfortunately, that the situation is going to get worse, and we may have the most conservative parliament since Brazil became a democracy again. But as the anti-rights movement are gaining more seats in the parliaments, not only in the federal parliament, but also in states and cities, they have recently started a new strategy to attack access to legal abortion in Brazil. They are presenting and they are approving bills with the same content in different states and cities. And I will give you two examples to understand better. They are presenting bills in different municipalities, and they were able to pass one of them that creates an anti-abortion campaign and says that the government should promote messages about the risk and the consequences of abortion. In Rio de Janeiro, a city that you may know because it is really famous in Brazil, they approved a bill that says that health services should display posters with anti-abortion messages. And the same bill was presented in many other cities too. As you can see, many of these laws are based on misinformation, and I think this is because states and cities in Brazil cannot change the exceptions for legal abortion in our country. To do that, the anti-rights movement must need to pass a law in the National Congress, which is much more difficult. As a response to their strategy, we are challenging the law, in those laws in courts after they are approved, and we have managed to suspend all of them. But I also think the anti-rights movement strategy has two goals. The first goal is to spread misinformation about abortion. I already talked about it. And the other goal is to exhaust our time and our resources as the feminist movement, because there are so many bills in different states and different cities, and it's very hard for us to follow all of them. And if we can follow all of them, it's very hard to always react. That's why the resolution that I told you before in the first answer is so important to us, because for many years we were mostly reacting and trying to stop the setbacks. And with the resolution, it was the first time in many years that we really created something based on our own agenda. But coming back to the question, what is interesting to notice when we compare the African Charter on the Family and the arguments of the anti-rights movements in Brazil is that they are very similar, the defense of the family and the defense of the life. But I think it's not only this. We can also see that the anti-rights movement is bringing human rights narratives into their arguments in Brazil too. They are saying that they are defending children's rights. They are saying they are defending women's rights too. And I think the arguments in Brazil, as I heard here in Africa too, are getting, the anti-rights arguments are getting more complex. And we need right now to find strategies to face that new reality and think about what other narratives we can put on the table to fight against the appropriation of the human rights language by the anti-rights movement. Thank you.
Thank you so much. All right, moving on. Audrey, the report that you shared about today sits at the intersection of disability, race, and consent. Three things this Baraza hasn't fully put into in the same room together. What does centering that intersection change about how we should be thinking about capacity and consent for everyone this week?
I'm gonna start just trying to use your questions and also the question that person
Yes,
asked
please.
to me. You listen to me? Um, One of the things that we have to think as a lawyer and human rights advocate is um, the rights of women's or black people advancing or advance when we call in the critical theory studies about the convergence of interest. That means in the reality we just see can push our rights when other interests are into that rights. For that reason, our rights, our public policies always are like weak and reversible because of this is the reality of the world. So I'm gonna start to talk or to answer is why we do research first to litigate because we as a lawyer have the responsibility to use our experience as a legal tool because we in some cases we can do it that so when we will litigate cases as the women with disability we got big issues is that the law, as I said before, the law create category that doesn't mention our necessity. And this is the law that we are using. So the first invitation is to stop to using the same universal interpretations to see what is the experience of black women. So this is the first thing that I have to tell you. We haven't found the answer, but what happened in the relationship with the state when we got these kind of researches is the state doesn't pay attention to us. We just do that research, and not only because we want to people get the informations that we make, but also is there another way to deconstruct the way that we learned how to use the law in the universities. So when we got all of that information about 20 women who do not know about the access to the abortions as a fundamental right, it's not only for the state, it's all for the empowerment our community with their own information. So the law have a responsibility with us as a black in Africa, in Latin America. The responsibility is the law is that it have been using to oppression. It have been using to interpret our rights. So Colombia also has a good framework, legal framework, because I mentioned it before, we got this idea of the mixed history of our country in every, like in Latin America. It's not general idea that we are not facing racism, that people is poor because people want, that women are getting pregnant poor because they just want to be poor. So the real discussion between behind, sorry, about that we can use research to change the public policies is we are facing a discussion about economic justice. And we are thinking that it's a discussion about just the law and the interpretation of treaty. For this reason, one of the gaps that we found in our research is that the responsibility to see our rights is in the law, of course, that we need the law. The law shapes the institution. But that law is racist, is patriarchal, and so many things that do not show our necessity. So when we go to the court with this kind of intersectionality, we do not expect to win the cases with our research. We just to put the narrative, the discussion in the table. That is the first step that we have to do, is the using the law, the using the court to put our conversations in the table. Even this is an interest of the powers, but is it the way also to distribute the power of the change the law, the change the institutions. So we take these cases, women with disability, to interpret the intersectionality, but it was more than that. Because we are, as a Latin American, we are the mirror. We face the same thing that you face here. It's the same pattern. But we want to look in another tool. And the law is a good tool, but for them. it not have been a good tool for us. So just to finish my interventions is until we finish this meeting, we have to think not only about the litigation, that is the main point of this event, but also the role that have another sources of the law. The research, the academy, the social philanthropy, the agenda that we are taking as us, but it's an universal agenda. So we have the possibility to recreate our way to see the right. In the research that I want to read today, we didn't ask the women what was the violation of rights, because we know it, and we have that knowledge. We just asked them, what is the autonomy looks like for you? What the institutional have to transform or to change to give you not an access, but a dignity life with your intercessions. So that's the invitation that I'm gonna bring today more than say another words. We are using the same tool that they are using to pushing back. So we cannot continue to these kind of methodologies.
I think that's really powerful. I haven't heard that one before. Even if you know that you're not going to win, it's important to put the argument on the table. That's thank you so much. So moving on to Dr. Ndlovu. Dr. Ndlovu, if you had to say what a genuine reclamation of African legal identity looks like on this question, not a phrase or a panel title, but as something concrete and tangible, what would that be? If you can answer that question as well as a question from the gentleman at the back. Thanks.
Thank you very much. I think in my reflections, I had already touched on that, but maybe one or two issues just to hammer on what I had spoken to earlier. The issue that's being spoken about is the issue of lived realities, just grounding our laws, our policies, our programmatic interventions, our institutes in responsiveness to lived realities. And then when I was presenting our own case as Zimbabwe, maybe prioritization of the codification of laws so that they take effect quickly and address some of the gaps that I already pointed out to you as I was presenting on the trajectory on which our age of consent laws have evolved, and also the triangulation of laws. And another aspect is our solutions should not leave our people behind. For example, we have traditional leadership in areas, in some of the underrepresented areas. They should be involved in referral pathways. They should also be involved in maybe the sensitization of some of these issues, so that they are not only seen as adjudicators or maybe in traditional courts, but they own the processes and they also get to own the laws and make sure that their communities are sensitized, and they also apply some of these best practices in the adjudications that they do on the ground. And then to respond to the question, I think there were two questions around what, I think it's around the protocol on older persons. What do you think is the role of the older persons protocol? I would think that it comes to reaffirm issues around dignity and autonomy throughout the life cycle, that older persons still deserve the same dignity and the same rights that other ages also deserve. And it is also rooted in African values and respect for older persons. So issues around non-discrimination come to play, affirming protection from abuse. We know that sometimes as people get older, they become non-desirable, as was also spoken about yesterday. Then in Africa, there are issues around witchcraft. Sometimes someone is suffering from dementia and then they become accused of maybe trying to bewitch someone or being involved in witchcraft. So I think that protocol comes to protect older persons from situations of abuse and also from issues of property dispossessions. So in essence, protection from harmful practices and also to ensure that there is access to justice across the life course as well, because you are not too old to receive the dignity of justice. Yeah, so access to essential economic, social, and cultural rights and other social determinants also runs through that life cycle. And in closing, the issues around participation, older persons still have and should be accorded the right to participation and also to hold decision-making positions. Thank you.
Thank you so much, Dr. Ndlovu. All right. Sally, where has litigation or advocacy actually beaten the cultural authenticity defense? What worked and what still tends to win against you? If you can answer in 5 minutes, please.
Thank you so much. So I think where we want to make a determination in reflection and in us rewiring our collective energies and focus is to reflect also on having won and make a difference in girls' lives and communities. So I would say yes and partially not yet. So yes, in the fact that we now have the Africa human rights mechanisms with really soft laws being in place, different researches, capacity strengthening issues. We also now have legal gains in the past 10 years, you know, the whole decade we have seen, even our charter being the African Charter on children, being a solid instrument, you know, which protect rights, including even Maputo Protocol, you know, in a very expansive and progressive manner. We have also seen that while legal systems have been uneasy, so strategic litigation have established rights. We have seen parliaments reforming the laws. We have seen regional bodies creating peer mechanism and complementary, you know, non-state actors reports. It has, you know, brought in that kind of an accountability and oversight mechanism. So when we look at even the case of Mudzuru and the Minister of Justice in the Zimbabwean case, with young people, African lived experiences, I would say strategic litigation have placed the survivors as power holders. But what we are up against right now, we have the underground gang. When there is no birth registration, proving the age of the child have been something that have been hanging because the body politics of us being full figure like me, they'll be like, no, the girl is already ripe for marriage. The issue of argument around consent, the issue of resourcing, we are not adequately, and that whole selective application of law. Then the exceptions around judicial exceptions, parental consent, the issue of the monarchy that I made reference to, and then the issue where we have seen that the education curriculum under heritage education is beginning to bring in this bad behavior to looking into the survivor-centered protection mechanisms. So we have seen progress, though not as strong as it should be, where we still have even some of the gaps that then say because they are minors and children, there are still legal gaps and loopholes, you know, around them actually nullifying the resolution of that relation, that union, because I don't want to call it a marriage, it is rape. And then the issue of inheritance, the issue of child maintenance, the protection, even the social services architecture and in the marriage situation in terms of children. So generally, when we look at what are some of the emerging gaps and opportunities, or what are we up against, we are up against some of the narratives that, you know, the anti-rights gang is coming to destabilize the political will that took longer, quite a very long time to put together. And, you know, when we look also at issues around what works, it's centering the girls and women. as applicants and as witness. And there's continuous support mechanism in terms of access to justice for them. And the whole social protection and safeguarding manner, even through strategic litigation. Then the backlogs requires us to tool up to make sure that, when reports are happening, we accelerate access to justice and reduce the cost. Then the age of children, being 18 as a non-negotiable, the batch registration really need to be on board. So there was a question that was raised on, do we need to open the conversation around discussion on who a child is? We have always been talking about children, and for us as a continent, as a region, to establish even structures, systems and processes and our protocols and technical working groups around that, we are clear on who a child is. What have been lagging behind is where sometimes in our ecosystem of governance and duty bearers, the child is being claimed by many, but no one is taking responsibility. So you then see there's child protection, there's compartmentalization of children's rights, and no one then shows up to duty. And then when we look into the institutionalization of the best interest of the child in terms of children being in the parliamentary processes, being in the decision-making platforms of our human rights mechanisms and our parliamentary and governance system from local government. We have the child parliamentarians, we have different platforms, but we have not fully institutionalized the best interest and the child participation is provided for by the Charter. So what we are up against is some of the political will reforms and us willing to do the work as it should. And we have also seen, what we are up against being evolving. When the culture narrative, we have mastered it, it evolves into the forum. If it's now from the forum, it evolves into we don't have resources, it evolves into so we are shooting a moving target in terms of our different advocacy, but we are sitting on gains of different generations of advocacy, and we need to keep and not tire, but continue pushing back with courage, with solidarity, speaking truth to power, and also beginning on the table, because we have sophisticated duty bearers who use excuses of what evidence, even if we repeat. So let's continue repeating, let's continue advocating, let's continue litigating, and let's continue in advocacy. And let's also take it personal, because people who are solution holders know some people that knows people. So it's time for us to accelerate some of the advocacy we used to engage in, the intergenerational, cross-sectoral, and ensure that beyond legal reform gains, we sustain it with political will, with movement building continuously, because people and children are not projects. They don't live in project cycles. It's a lifelong. And with duty bearers, the door swings both ways. While we are moving and not demanding rights and litigating, also the institutions need to be strong, protected, and independent, with strong oversight and accountability mechanisms and resourcing. Thank you, and over.
Thank you so much. Thank you for those reflections. And then to close us off, Masupatsila, the African Commission and the African Committee of Experts on the Right and Welfare of the Child have already shown what cross-mechanism collaboration looks like through their joint general comment on ending child marriage. Given what we've heard today from Brazil and Colombia, what would it take to extend the same kind of collaboration south to south in shorter than 5 minutes, please?
Thank you so much, Madam Moderator. Am I audible enough? Okay. First, before I go to your question, I will attend to the question that was raised by Madam Spongile on issues around how the mechanism of the Special Rapporteur on the Rights of Women in Africa is championing the ratification of the AU Convention on the Elimination of Violence Against Women and Girls. I would like to point out that the Office of the Special Rapporteur has had engagements with stakeholders, with civil society organizations, and they've listened to the challenges, the issues that are being raised from the convention. The Office of the Special Rapporteur has maintained always that instruments like the convention, they are negotiated instruments They are instruments that came about as a result of consultation with various stakeholders. And just like any other instruments, it may happen that sometimes not every article, not every provision that people envisage to see is able to make it, because these are negotiated instruments. So the Office of the Special Rapporteur has looked at the analysis that has been provided on the gaps that are being identified in the convention. But as was highlighted by Madame Salanja yesterday, this is an instrument of the African Union which has already been adopted. It's an instrument that looks at resolving the problems around violence against women, which are very widespread across the continent. It builds from Maputo Protocol, which now goes ahead, highlights the obligations of member states and other stakeholders towards the elimination of violence against women and girls. So at the end of the day, our object is to actually focus on what this instrument seeks to do, what is the value addition, and we realize that it actually addresses issues of violence, emerging issues even, which were not which were not before in the past addressed by such instruments. It talks about issues of technology facilitated violence, issues of femicide, and it offers a broad scope of protection for women and girls. So the Office of the Special Rapporteur realizes that there are gaps, and it has taken cognizance of the analysis that highlights these gaps. But as I highlighted earlier when I came onto the podium, the mandate of the Special Rapporteur on the Rights of Women also has a mandate to in its implementation, and it works through generating normative frameworks like the general comment. If ever there are gaps that are realized, it then uses its mandate to now explain further what needs to be done and address the gaps that can be addressed maybe in a law. We look at the general comment that was done on Article 14 of the Maputo Protocol. So the same also applies, that the gaps are there, they have been identified, but as the instrument comes into force, there's still an opportunity that through soft laws, the Commission will still be able to speak into those gaps that have been identified. Maybe without wasting much time, I would also now respond to the question that we have posed around South-to-South collaboration. The collaboration between the African Commission and the African Committee on the Rights of the Child, it was mainly, it came about by realizing that the two institutions have a common mandate, especially around the rights of girls, because Maputo Protocol, when it gives what a woman is, it also includes girls. So when we are now looking at issues around child marriages and other harmful practices, both institutions actually do work around that. Their mandates covers those. So what made that collaboration come about is by realizing that they both had similar mandates and similar challenges are being raised, and then they came together to co-create that general comment to then give guidance to member states and stakeholders. So from what I've heard today in this panel, I've listened to the interventions from our colleagues from Brazil, from Colombia, and we realize that the issues that they are raising, they are also issues that we see here in Africa. So that already tells us that there is ground for collaboration. Once we see that the issues are similar, we still have our different normative frameworks, but at the end of the day, we are all striving towards ensuring that women and girls are able to access their rights. So I believe that South-to-South collaboration is also possible if the institutions come together, realize the challenges that we face, and come together to co-create solutions. Thank you.
All right, thank you so much. Well said. In closing, what we've seen today is the very thesis of this panel in action. 5 jurisdictions across 3 continents, united in a single argument, read together rather than in isolation. Thank you to our brilliant panelists as well as Sally online, and to all of you in the audience. We look forward to carrying this vital conversation on sovereignty, decoloniality, age as a key determinant, and the reclamation of African legal identity into the rest of the Baraza. Thank you, Ndatenda.
Thank you very much. That's not enough. We've learned a lot. We've done a south-to-south exchange. So we'll request the panel to take a picture for the panel, and for the rest of us, we're going to have a tea break for 15 minutes and resume again at 11:30 for the next session. Remember, we talked about community policing. Make sure you look at who is around your table, and they are back, seated at 11:30. See you then.
Déjame sacar esto. Gracias.
Salió muy bien a pesar de la presentación.
Esta fue la primera vez en toda mi existencia que hago una presentación.
Para mí
Lo
también
que voy a hacer es que voy a seguir haciéndolo así me muera de miedo por dentro, porque una de las principales barreras siempre de poder realmente hacer es el idioma, y eso no se va a convertir en una barrera por mí. Esa fue la decisión que saqué. Como no voy a seguirlo haciendo así sea lo que sea. Intento
Start with Spanish conversation, but you guys were great. So yeah, and you going up again? Yes.
What is your turn?
Tomorrow morning. Yes. I don't know what the questions are, what the format is.
But we have to look them over there.
It was the same. Yeah, we received the questions yesterday at 5 p.m.
There were supposed to be questions. She hasn't come.
We asked, and it was like, no presentation. And they are asking things about the order, so we need to bring new ideas to the because I was prepared to do something. And then she asked about what we were talking yesterday. So what we did to put everything during the night.
Before you and I were born, our forefathers and mothers had full custody of a priceless gift.
A gift that gave ceaselessly, a lifeline that linked generations endlessly, a gem that was shamelessly stepped on.
Our kurambire, our forefathers and mothers, they understood. They understood the value and context of this, our sexuality complex. To them, it was more than just intercourse.
It was a source and a resource of continuity and multiplication. One without a replica, of course, a treasure of invaluable pleasure, devalued by foreign values. To our forefathers and mothers, Eriba Jajafe, sexuality was a place of pride and purity that shaped the community, a place where identity made love to responsibility and gave birth to hope.
A hope that now hangs on the ropes of the foreign man on top. Kwa mababu wetu, to our forefathers and mothers, reproductive justice was the key.
The spiritual key that unlocked possibilities for the society until it got locked up by ubukila, slavery.
To our forefathers and mothers, sexuality was poetry, a metaphor of succession,
a representation of the interconnecting political, social, and economic fabrics. Sexuality existed above the confines of the white man's matrix.
Our forefathers and mothers,
listened to the whispers. The whispers of equity and agency, the whispers of reproductive justice and mediation, the whispers that were wisely woven into socialization until they were muffled by the noise of colonization, a distortion that still rattles the African civilization. To our forefathers and mothers, the fabric of being was like water, freely following the flow of function with a clear introspection of home. A home where stigma had no seat at the table. A community where masculinity and femininity danced in the kitchen of necessity and in the hunting ground for survival.
Their purity of mind was unrivaled. They were the Venda of South Africa,
the Nandi of Kenya,
the Kuria of Tanzania,
the Bara of Madagascar, until they tasted the tears of Okonko.
And things fell apart as gushing white waters formed a river between them and their identity,
between us and our identity. Now look at us. See. A society drowning in a sea of delusion, lungs submerged by waters of confusion, drowning. Our sexuality is drowning because we have lost touch of our ancestral grounding. Look at us. See a sea of confusion, a sea of delusion, of floating spirits in bodies we no longer own, chanting creeds of autonomy, recycling and reusing narratives that continue to reduce our own ideologies. Look at us. See. Lava. Leva, Bona, Tazama.
Look at gender. Before that, throw away your foreign lenses.
There's a lot to unlearn before we come to our senses. See, or rather, unsee. Unsee the notion that there is sin in your sexuality. Abandon that narrative because it is not our own.
Let us weave our own paths of reproductive justice with threads of gender, race, and class intertwining, with diversities converging at the threshold of an African identity.
Let us mold our own methods of mediation, form our own fields of assimilation, and put a stop to this disease that is discrimination.
Let us rise up with voices united and strong in the fight for justice where all belong. For the path to liberation is not singular. It's as complex and diverse as our ancestral root system.
Let us follow the teachings of our roots. Roots like Mulondo that instruct the male anatomy. Forget Victorias and remember the secrets of the acacia tree that instructs us to honor our bodies.
Let us reclaim our reproductive justice, an Afrocentric approach of breaking chains, celebrating the resistance that flows in our veins.
Together, we advocate, educate and inspire, building communities that stand strong and aspire. In the litigation of justice, we find our voice, reimagining a future where Africa can rejoice.
Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar. Toda criança merece um futuro seguro e livre de responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. Toda criança merece um aborto legal é crucial para garantir responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. Maternidade não é coisa de criança. O direito ao aborto legal é crucial para garantir isso. Acesse o site criançanãoemãe.org.br e saiba como ajudar. Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar.
Historically, however, the healthcare system has been designed for a universal user, an individual without ethnicity, territory, or community. As a result, the system was created without taking into account an intersectional or anti-racist approach. This institutional racism discriminates against and renders invisible the healthcare system specific to Black communities, and it also restricts their access
Toda
to
criança
healthcare.
merece um futuro seguro e livre de responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar.
Their ethnic identity and their communities. They are true political agents. And they are the key piece that was missing from the health ecosystem and the movement for sexual and reproductive rights. But it has taken years to achieve this recognition, and that's where we are working. At ILEX, we have addressed this issue through 3 lines of work. First, in collaboration with Association of Black and Indigenous Midwives in Colombia, we've pursued the strategic litigation against the government to secure recognition by the Constitutional Court of the work of midwives in areas not served by public health services. Second, we conduct social legal research with an ethnic focus to document how they transmit their knowledge, demonstrating that their work is a matter of life and death when it comes to access to information about voluntary termination of pregnancy. And third, we support traditional midwives in creating a practical guide that outlines how they should be trained and how to interact with the Colombian healthcare system. Our next step is to turn this progress into a tangible reality to ensure that midwives are fully integrated into Colombia's healthcare system and included on the list of healthcare providers, guaranteeing that Black women can exercise their reproductive rights in accordance with their own ways of life. At ILEX, we transform recognition into racial justice and
Toda
sexual
criança
and
merece um futuro
reproductive
seguro e
sovereignty
livre de responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança.
A long time ago, before you and I were born,
Acesse
our
o site
forefathers and mothers had full
criançanãoemãe.org.br
custody
e saiba
of
como
a
ajudar.
priceless gift.
A gift that gave ceaselessly, a lifeline that linked generations endlessly, a gem that was shamelessly stepped on.
Our kurambire, our forefathers and mothers, they understood. They understood the value and context of this, our sexuality complex. To them, it was more than just intercourse.
It was a source and a resource, a resource of continuity and
Toda criança
multiplication,
merece futuro
one
seguro
without a
e
replica,
livre
of
de
course,
responsabilidades
a
que não
treasure
são
of
suas.
invaluable pleasure,
Ser
devalued by
criança e ser
foreign
mãe são
values.
realidades
To our
incompatíveis.
forefathers and mothers, Eriba
O
Jajafe,
direito ao aborto
sexuality
legal é
was a
crucial para garantir
place of pride and purity that shaped the community, a place where identity made love to responsibility and gave birth to hope.
A hope that now hangs on the ropes of the foreign man
Acesse o
on
site
top.
criançanoemãe.org.br
To our forefathers and mothers, reproductive justice was the key.
The spiritual key that unlocked possibilities for the society until it got locked up by ubukila, slavery.
To our forefathers and mothers, sexuality was poetry, a metaphor of succession,
A representation of the interconnecting political, social, and economic fabrics. Sexuality existed above the confines of the white man's metrics.
Our forefathers and
Toda
mothers.
criança merece futuro
Listened to
seguro
the
e livre de
whispers,
responsabilidades
the
que não são
whispers of
suas.
equity and agency, the whispers
Ser
of
criança e ser mãe
reproductive
são
justice
realidades
and mediation,
incompatíveis.
the whispers that were wisely woven
direito ao
into
aborto legal é
socialization
crucial para
until
garantir
they
isso.
were muffled by the noise of colonization, a distortion that still rattles the African
Maternidade não é
civilization.
coisa de criança.
To our forefathers and mothers, the fabric of being was like water, freely
Acesse o site
following the flow of
criançanoemãe.org.br
function with a
e
clear
saiba como
introspection of home. A home where stigma had no seat at the table, a community where masculinity and femininity danced in the kitchen of necessity and in the hunting ground for survival.
Their purity of mind was unrivaled. They were the Venda of South Africa,
The Nandi of Kenya,
the Courier of Tanzania,
the Bara of Madagascar, until they tasted the tears of Okonkwo,
and things fell apart as gushing white waters formed a river between them and their identity,
between us
Toda
and our
criança merece
identity.
futuro seguro
Now
e
look at
livre
us.
de responsabilidades que
See,
não são
a
suas.
society drowning in a sea of delusion,
Ser criança e ser
lungs
mãe são
submerged by
realidades
waters of
incompatíveis.
confusion, drowning. Our
Direito ao
sexuality is
aborto
drowning
legal é
because we have
crucial
lost
para
touch of
garantir
our ancestral grounding. Look at us. See a sea of confusion, a sea of delusion, of
Maternidade
floating
não é
spirits
coisa
in
de
bodies
criança.
we no longer own, chanting creeds of autonomy, recycling and
Acesse o
reusing
site
narratives that continue to reduce our own
criançanoemãe.org.br e saiba como
ideologies.
ajudar.
Look at us. See, lava, leva, bona, tazama.
Look at gender. Before that, throw away your foreign lenses.
There's a lot to unlearn before we come to our senses. See, or rather, unsee. Unsee the notion that there is sin in your sexuality. Abandon that narrative because it is not our own.
Let us weave our own paths of reproductive justice with threads of gender, race, and class intertwining
criança
with
merece
diversities
futuro seguro
converging
e
at the
livre de
threshold
responsabilidades que
of
não
an
são
African identity.
Let us mold our own
Ser criança
methods
e
of
ser mãe são
mediation,
realidades
form our own
incompatíveis.
fields of assimilation, and put a stop
direito ao
to
aborto
this
legal
disease
é
that is
crucial para
discrimination.
garantir
Let us rise up with voices united and strong in the fight for justice where all
Maternidade
belong.
não é coisa de
For the
criança.
path to liberation is not singular. It's as complex and diverse as our
Acesse o site
ancestral root system.
criançanoemãe.org.br
Let us follow the
e
teachings
saiba
of our
como ajudar.
roots. Roots like Mulondo that instruct the male anatomy. Forget Victorias and remember the secrets of the acacia tree that instructs us to honor our bodies.
Let us reclaim our reproductive justice, an Afrocentric approach of breaking chains, celebrating the resistance that flows in our veins.
Together, we advocate, educate and inspire, building communities that stand strong and aspire. In the litigation of justice, we find our voice, reimagining a future where Africa
Ser
can
criança e ser mãe
rejoice.
são realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança. Acesse o site criançanoemãe.org.br e saiba como ajudar. Toda criança merece um futuro seguro e livre de responsabilidades que não são suas. Toda criança merece um futuro seguro e livre de responsabilidades que não são suas. O direito ao aborto legal
Ser criança
é
e ser
crucial
mãe
para
são
garantir
realidades
isso. incompatíveis. O direito ao aborto legal é crucial para garantir maternidade não é coisa de criança. Maternidade
Acesse o
não
site
é coisa de
criançanãoemãe.org.br e saiba como ajudar. Acesse o site criançanãoemãe.org.br e saiba como ajudar.
In Colombia, guaranteeing the sexual and reproductive rights of Black women requires an understanding of their territories and ways of life. Historically, however, the healthcare system has been designed for a universal user, an individual without ethnicity, territory, or community. As a result, the system was created without taking into account an intersectional or anti-racist approach. This institutional racism discriminates against and renders invisible
Toda
the
criança
healthcare
merece um futuro
system
seguro
specific
e
to
livre
Black
de responsabilidades que não são
communities, and it also
suas.
restricts their access to healthcare. At
Ser
ILEX
criança e
Ação
ser mãe são
Política, we
realidades
have
incompatíveis.
identified this problem. Found that when it comes
O direito
to
ao aborto
sexual
legal
and
é
reproductive
crucial
health,
para garantir
there is
isso.
one key group that plays a vital role in ensuring that women's rights are upheld in accordance
Maternidade
with their
não é
own
coisa
ways
de
of
criança.
life. Traditional midwives. Traditional midwives are not merely cultural
Acesse o
agents
site
who manage women's health during
criançanãoemãe.org.br
pregnancy
e saiba
and
como ajudar.
childbirth. Midwives ensure access to information and foster the connection between women, their ethnic identity, and their communities. They are true political agents, and they are the key piece that was missing from the health ecosystem and the movement for sexual and reproductive rights. But it has taken years to achieve this recognition, and that's where we are working. At ILEX, we have addressed this issue through 3 lines of work. First, in collaboration
Toda criança
with
merece um
Association
futuro
of
seguro
Black
e
and
livre de
Indigenous
responsabilidades que
midwives
não
in
são
Colombia,
suas.
we've pursued the strategic litigation
Ser
against the
criança e ser
government
mãe
to
são
secure
realidades
recognition by the
incompatíveis.
Constitutional Court of the work of midwives
Direito ao
in
aborto
areas
legal
not
é
served
crucial
by
para
public
garantir
health services. Second, we conduct social-legal research with an ethnic focus to document how they
Maternidade
transmit
não é
their
coisa de
knowledge,
criança.
demonstrating that their work is a matter of life and death when it comes to access
Acesse o
to
site
information about voluntary
criançanãoemãe.org.br
termination
e saiba
of
como
pregnancy.
ajudar.
And third, we support traditional midwives in creating a practical guide that outlines how they should be trained and how to interact with the Colombian healthcare system. Our next step is to turn this progress into a tangible reality to ensure that midwives are fully integrated into Colombia's healthcare system and included on the list of healthcare providers, guaranteeing that Black women can exercise their reproductive rights in accordance with their own
Toda
ways
criança
of life.
merece um futuro
At ILEX,
seguro
we
e livre
transform
de responsabilidades que
recognition
não são
into
suas.
racial justice and sexual and
Ser
reproductive
criança e ser
sovereignty
mãe
for
são
Black
realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança.
Acesse o site
A long time ago,
criançanãoemãe.org.br e saiba
before
como
you and
ajudar.
I were born, our forefathers and mothers had full custody of a priceless gift.
A gift that gave ceaselessly, a lifeline that linked generations endlessly, a gem that was shamelessly stepped on.
Our kurambire, our forefathers and mothers, they understood. They understood the value and context of this, our sexuality complex. To them, it was more than just intercourse.
Toda criança
It was a
merece um futuro
source
seguro
and a
e
resource,
livre de
a
responsabilidades que não
resource
são
of
suas.
continuity and multiplication. One
Ser
without
criança
a
e ser
replica,
mãe são
of course,
realidades
a treasure
incompatíveis.
of invaluable pleasure,
O direito
devalued
ao
by
aborto legal
foreign
é
values.
crucial para
To our
garantir isso.
forefathers and mothers, Eriba Jajafe, sexuality was a place of pride and purity that shaped the community, a place where identity made love to responsibility
Acesse
and
o
gave
site
birth to hope.
criançanãoemãe.org.br
A hope
e
that
saiba
now
como
hangs on
ajudar.
the ropes of the foreign man on top. Kwamababu Wetu, to our forefathers and mothers, reproductive justice was the key.
The spiritual key that unlocked possibilities for the society until it got locked up by Ubukila, slavery.
To our forefathers and mothers, sexuality was poetry, a metaphor of succession,
a representation of the interconnecting political, social, and economic fabrics. Sexuality existed above the confines of the white man's matrix.
Our forefathers and mothers.
Okoko listened to the whispers of equity and agency, the whispers of reproductive justice and mediation, the whispers that were wisely woven into socialization until they were muffled by the noise of colonization, a distortion that still rattles the African civilization. To our forefathers and mothers, the fabric of being was like water, freely following the flow of function with a clear introspection of home. A home where stigma had no seat at the table, a community where masculinity and femininity danced in the kitchen of necessity and in the hunting ground for survival.
Their purity of mind was unrivaled. They were the Venda of South Africa,
the Nandi of Kenya,
the Kuria of Tanzania,
the Bara of Madagascar, until they tasted the tears of Okonko,
and things fell apart as gushing white waters formed a river between them and their identity,
between us and our identity. Now look at us. See, our society drowning in a sea of delusion, lungs submerged by waters of confusion. Drowning. Our sexuality is drowning because we have lost touch of our ancestral grounding. Look at us. See a sea of confusion, a sea of delusion, of floating spirits in bodies we no longer own, chanting creeds of autonomy, recycling and reusing narratives that continue to reduce our own ideologies. Look at us. See, Laba, Leba, Bona, Tazama.
Look at gender. Before that, throw away your foreign lenses.
There's a lot to unlearn before we come to our senses. See, or rather, unsee. Unsee the notion that there is sin in your sexuality. Abandon that narrative because it is not our own.
Let us weave our own paths of reproductive justice with threads of gender, race, and class intertwining with diversities converging at the threshold of an African identity.
Let us mold our own methods of mediation, form our own fields of assimilation, and put a stop to this disease that is discrimination.
Let us rise up with voices united and strong in the fight for justice where all belong. For the path to liberation is not singular, it's as complex and diverse as our ancestral root system.
Let us follow the teachings of our roots. Roots like Mulondo that instruct the male anatomy. Forget Victorias and remember the secrets of the acacia tree that instructs us to honor our bodies.
Let us reclaim our reproductive justice, an Afrocentric approach of breaking chains, celebrating the resistance that flows in our veins.
Together, we advocate, educate and inspire, building communities that stand strong and aspire. In the litigation of justice, we find our voice, reimagining a future where Africa can rejoice.
É crucial para garantir isso. Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar. Toda criança merece um futuro livre de responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar.
In Colombia, guaranteeing the sexual and reproductive rights of Black women requires an understanding of their territories and ways of life. Historically, however, the healthcare system has been designed for a universal user, an individual without ethnicity, territory, or community. As a result, the system was created without taking into account an intersectional or anti-racist approach.
Toda criança merece um futuro seguro e livre de responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar.
Who manage women's health during pregnancy and childbirth. Midwives ensure access to information and foster the connection between women, their ethnic identity, and their communities. They are true political agents. And they are the key piece that was missing from the health ecosystem and the movement for sexual and reproductive rights. But it has taken years to achieve this recognition, and that's where we are working.
Toda criança merece um futuro seguro e livre de responsabilidades que não são suas. Ser criança e ser mãe são realidades incompatíveis. O direito ao aborto legal é crucial para garantir isso. Maternidade não é coisa de criança. Acesse o site criançanãoemãe.org.br e saiba como ajudar.
When it comes to access to information about voluntary termination of pregnancy. And third, we support traditional midwives in creating a practical guide that outlines how they should be trained and how to interact with the Colombian healthcare system. Our next step is to turn this progress into a tangible reality to ensure that midwives are fully integrated into Colombia's healthcare system and included on the list of healthcare providers.
Delegates, welcome back. Can we see by a show of hands which table did the best community policing? Can we see which table has all the members there? Okay, let's see which one. Okay, table 8, the table that the most community the members there. Can you clap on your table, bang the table? We need to hear the loudest noise. And then which table is walking out in shame that doesn't have its delegates there? Can we look around? Okay, so thank you for rallying yourselves back for the session. We're going to go into the next session. Tech team, can you please bring back our delegates that are online? We are going into the next session, which is going to talk about mental capacity, decisional autonomy, and the right to health care. Because these intersections, we've had a conversation around intersections that we need to explore deeper. And my role here is to introduce to you the moderator for that session, who will take it on from here. I'd like to invite Nimrod Amuhumuza, who is a legal scholar. He works around an intersection of a cross range of issues like children's rights, climate justice, and SRHR across Africa. He heads research at Afya na Haki, and he leads the institution's research strategy. He holds a Bachelor of Laws, cum laude from the University of Pretoria, and is finalizing his LLD at the University of Western Cape, and is admitted to practice law in Uganda. Nimrod, you're welcome to take it on from here.
Thank you so much, Salome. Good morning, everyone. How are we feeling after break tea? and it's a bit warmer, right? So I want us to have a conversation that's a bit to try and problematize the issues that we've been discussing, issues around age. And I wanted to start by asking you to reflect before I invite my panelists. Ask you to reflect on some of these things. From your own community, from your own upbringing, or from your own experiences, does anyone here remember the moment that signaled that they were no longer a child and had become an adult? Do you remember that particular moment? If you didn't have recourse to the calendar or the clock, or for those who are a bit older, do you remember the moment you transitioned into elderhood? And then secondly, again from your own communities, from your own upbringing, what marker, what ritual, what event, what moment signaled that a child has now become an adult? In many of our communities, it has to do with things like circumcision, it has to do with marriage, it has to do with the onset of certain secondary and primary sex characteristics, isn't it? Right? So I want us to sit with that for a moment because, as I mentioned at the beginning, we need to problematize the issues of age as we use it today. Because even within the scientific discipline, it is not a settled question. If you ask a neuroscientist, and I know we have some psychiatrists in here, but they're not necessarily neuroscientists. If you ask a neuroscientist, they'll tell you that the human prefrontal cortex, the part of the brain that is responsible for making judgments and controlling impulses and planning and weighing consequences, does not mature until the mid to late 20s, right? You've had that. You've had this, the science is trying to find this question of at what point is someone fully mature, is someone fully an adult? If you ask a physician tracking pubertal development, and they will tell you that by the mid to late teens, a person's sexual and reproductive characteristics are already fully mature. By mid to late teens. So this is sometimes years or even a decade before that same person's brain has finished developing the judgment to navigate the consequences of that maturity. If you ask a community leader, if you ask a religious leader, if you ask some of those individuals that are responsible for the initiation rituals, they'll describe and they'll give you an entirely different response, an entirely different